All right. Good evening, everybody. Can you all hear me? Thumbs up. Okay. Great. Well, welcome and thank you so much for coming tonight. Thanks for the thumbs up. I'll continue to let people in as they enter the waiting room. So I'll keep an eye on that. Thank you for attending our last speaker series of the season. We're really fortunate to have Patrick join us tonight and share his expertise with us all. Patrick Fitzgerald, if you don't know him already, is a native of Talbot County. He graduated from Easton High School, so he's local, and completed his undergraduate degrees in accounting and economics at the University of Pittsburgh. He earned his JD at the University of Baltimore School of Law, and after law school, Patrick completed additional coursework at the University of Baltimore, earning an LLM, which is a Master of Laws in Taxation, and a certificate in estate planning. He's practiced law in Easton since 2008. And if you are interested in working with Patrick, I can certainly help connect you with him after the meeting. If you're not familiar, which I think everyone here is familiar with Wye River Upper School, but if you're not, we are an independent school located in Centerville, Maryland. We serve grades 8 through 12 and specialize in educating students with learning differences. My name is Katie Lillard. I'm the Director of Enrollment and Communication at the school, and I would love to show you around campus. So anyone who hasn't been to campus, please come on over. We can share a cup of coffee and take a look around, and love to have you there. And I'd love to introduce Patrick now. So welcome, Patrick.
Okay, thank you, Katie. So as Katie said, I've been practicing law here on the Eastern Shore for about 15 years now. And pretty much all of my practice involves what we're going to talk about tonight, which is estate planning. So hopefully I can provide you with some insight on ways that you can plan for your estate to protect your children and family through those documents that we'll talk about tonight. So I think Katie did a good job of kind of giving you my background. So that takes number one off of my list. There's going to be three main documents that we will talk about tonight. And we'll kind of go through each of those and why they're important and just some topics about each one. And then we will leave some time at the end for questions and try to stay as close to the 7:30 end time as we can, of course. And then if you have questions after that, as Katie said, you can contact her and she can give you my email and you can be in touch with me with follow-up questions about the presentation or anything we talk about. So the three documents we're going to talk about tonight that I believe everyone should have as part of an estate plan. The first is a will, the second is a financial power of attorney, and the third is a healthcare power of attorney or advance directive. So we'll go through each of these and talk a little bit about them. Most of my conversation tonight is going to revolve around sort of planning for a family or a single person with children. As I'm assuming most of you are maybe parents of students or know students at the school, maybe have a family of your own that maybe don't have kids that attend the school. But I'm going to gear my discussion towards that, but I can also answer some questions at the end about other situations if time permits. So let's dive into the will first. The first question that a lot of people ask is, well, why do I need a will? You know, my property is titled jointly with my spouse, or I really don't feel like I have, that many assets. I have a mortgage on my house. Do I really need a will? And I'm of the opinion that everyone needs a will. And there's a few reasons for that. The first main reason is that a will allows you to dictate yourself the distribution of your assets when you pass away. If you die without a will, then state law directs where your assets will pass at your death, and how they will pass. So at a minimum, a will is important because it lets you tell everyone what your wishes are with regard to your property when you die. The second reason is that a will allows you to choose who will handle your estate. So that in Maryland, that's called the personal representative. You may have heard this person referred to as an executor. If you don't have a will, there's a certain hierarchy of people who could petition the local orphans court in Maryland to be the personal representative of your estate. If you have a will, you get to say who you'd like your personal representative to be. The third reason, and probably one that's very important to most of you here tonight, is that a will allows you to nominate a guardian for any minor children or even adult children that may need a guardian if you're no longer living. So again, if you did not have a will, there'd be a certain hierarchy of individuals who could petition the circuit court to be a guardian of a minor child or other ward. And it may not be who you really wanted to act as guardian in your place. So those are three major reasons that we want to put a will in place. Really allows you to control the situation and the distribution of your assets when you pass away. So let's talk a little more specifically about how we would structure a will for a family. So for instance, let's say we have a family with 2 children or a single individual with 2 children. Either case, the structure will be similar. The first thing that you're going to think about when you go to sit down with someone to prepare your will is who your fiduciaries will be. So the fiduciaries are people that have responsibility under your will. So the first, again, is that personal representative or executor. That's the person that's going to handle your estate when you pass away. And that person would most likely work with an attorney and work with the Register of Wills to go through probate or an estate administration process. So you'd want to choose someone who you believe can navigate that process with the help of an attorney that can guide them step by step. Another fiduciary you may have in your will is a trustee. And we're going to talk about why you might have a trustee in a few minutes. And then again, the third fiduciary you would have under the will would be who would be the guardian of any minor children if you or your spouse were not living or the child's other parent were not living. And this person would then be able to go to the circuit court and petition to be appointed guardian and to take care of the children in your absence. The second step of the will, after we've chosen who's going to be responsible for handling the assets and for managing the affairs after you pass away, is how do we want to manage those assets? So when you pass away, if assets are titled jointly with a spouse, or you have beneficiary designations on retirement accounts and so forth, those assets will pass outside of your will, okay, directly to the joint owner or the beneficiary you have designated on that retirement account or life insurance policy. But to the extent that maybe you're the surviving spouse or you're a single person and you have assets in your name alone, then those assets are going to be governed by your will. And especially in cases where we have minor children, we have to decide how we'll protect those assets if the children are minors when you pass away. So frequently what we'll do in a will is to create a testamentary trust. And this is a trust created within the terms of the will that has provisions for how the assets can be used for a child's benefit. So for instance, a will could say that I leave all of my property to my surviving spouse. And if my surviving spouse and I are both deceased, then my assets will go into a trust for my son. And we name a trustee of that trust under the will, and that person manages those assets. And the trust says that the trustee can use those assets, the income and the principal, for the child's health, education, maintenance, and support at a very basic level, but also can have discretion to use principal or income for all sorts of expenses, such as a wedding, to purchase a home, to start a business, and so forth. So that trustee is able to provide for that child while protecting the assets, until the child becomes of an age that we believe they could manage the assets. Typically, that's not 18. I see most clients choosing maybe age 25 or 30 in their documents so that a child has matured and can understand, the gravity of having assets belong to them and shepherd those assets wisely. So that's one example of the trust. For a family or a single person with multiple children, sometimes we would use something called a common fund trust. What that trust says is that if I've passed away and I have, let's say, 3 children, then I want all of my assets to go into one common trust for all 3 of my children until the youngest child turns a certain age. For instance, maybe the youngest child gets through college or is of an age where they're out on their own working. The idea being that we're treating the assets similarly to the way you would if you were still living, meaning most of us wouldn't have columns and say, well, I've spent this on child 1, so no more, and they get no more. Really what we do is use our assets to try to get all of our children to where they need to be, and that's what this trust would do. And then when that youngest child turns whatever age we choose, sometimes frequently it's age 21 or 22, those assets would then be divided equally among the children and maybe held in trust a little longer, again, until maybe they reach age 25 or 30. But then they'd each have their own trust, similar to the first trust that I explained to you. Another type of trust we might have in a will for a child is a trust that doesn't terminate at a certain age, a discretionary trust that goes on for the child's entire lifetime. Why would we have this? Well, it could be a minor child or an adult child that the person who's writing the will doesn't believe can really manage assets really at any point. And we really want to have those assets protected for an extended period of time for their lifetime. And then the trust would say where the remaining assets go when that child passes away years down the line. Another reason that we may have that type of trust is if a child has special needs, meaning we want to have a discretionary trust set up that wouldn't prevent that child from obtaining benefits, maybe from the state of Maryland or federal benefits, but that can be there as a supplemental supplemental pot of assets to support that child while not creating a problem for those types of benefits. And then the trustee would have discretion to use those assets for the benefit of the child. We'd have some specific wording there that would make sure that any benefits weren't, that we didn't put any of those benefits in jeopardy. And that's a trust we frequently use. You may see it referred to as a third-party special needs trust, meaning it's created by a third party, not the special needs individual themselves. This one is created in your will at the time you pass away, but it could also be created as a separate trust during your lifetime. This is important, I think, because if you didn't have a will and you had a minor child, the default would be that they could inherit assets at 18. And that's really not what most people would intend, I think. So this trust concept, I think, is important to protect these assets if you pass away, particularly if you think about the assets that might be involved. You may have a term life insurance policy that would pay into your estate that might be, a large sum of money. You have your home, you have retirement accounts and so forth. And all these assets would come into that trust and support the child without them being able to have direct access to it themselves until that certain age. The other important concept with the special needs trust, a third party special needs trust, like I just described, allows you to choose who the end beneficiaries of the trust will be at the death of the primary beneficiary. So it could be other children, it could be other family, etc. If a special needs child were to inherit directly from you or from another individual, it's arguable that they would have to create what's called a self-settled special needs trust. And that's where they take that inheritance and actually through their guardian, put it in a trust themselves. And that's more difficult. There's sort of a state oversight procedure for those types of trusts. And the third party special needs trust is easier to deal with and is a little bit more flexible. So that's an important part of this estate plan if you have that situation. But at a bare minimum, a family with minor children or even children who are, maybe in their early 20s and maybe not ready to potentially inherit, we really want to think about how to protect those assets. And having a proper will done allows you to do that and allows you to determine who will be in charge of those assets for the child. Some other things to think about with the will. We talked a little bit about titling. The important thing to remember about titling of assets is that the titling of assets always controls over a will. So for instance, if you own your home jointly with another individual, that home will pass to that joint owner at your death 100%. If you own a bank account jointly with another individual, same thing. That account will pass 100% to that individual. If you have a retirement account and you have a beneficiary designated, that account is going to pass to that beneficiary outside of your will. Frequently, what we'll do with these beneficiary designations, though, on retirement accounts, for instance, is you may have a spouse or someone else named as your primary beneficiary. And then once your will was put in place, that included a trust, for a child or for your children, we would name that trust as the secondary beneficiary on your retirement account so that we can filter all these assets into that trust so that they're protected for the child. So there's sort of a three-step process when we think about the will. We have to think about who's going to be in charge. We have to think about how we want the assets to pass to our family. And then we have to think about other assets and how we need to manage those to make sure they're in line with what our wishes are as we state them in our will. So it's not as easy as I think just going online and maybe downloading a form or doing a legal Zoom. I do think it's important, and this is obviously a little bit self-serving, but I do think it's important that you sit down with somebody and go through those steps. I think the important part of also going through those steps is it helps you to organize your own thoughts about your estate. It helps you to really focus on what your assets are, where they are, how they're titled, so that then you can put together a clear picture for the people you've named to take care of things should you die sooner than expected. And then really once that will's in place, it's something you want to look at least every 5 years, if not before that. Obviously, if there's a major life event that has changed, then you want to look at it sooner. But at a minimum, you want to look at it every 5 years and say, have my wishes changed? Do I now want somebody else to be in charge when I pass away? Do I still need these trusts for my children? Have I done everything I can do to help, protect my children if I die? So that's sort of the will. Maybe I will stop now and take a few questions if anybody has any on on wills, and then we'll go on to maybe the other documents. Okay, I'll keep going then. And then if you have questions or think of questions at the end,
I
just
think
let
we
me
do have
know.
one question, Patrick.
Okay.
Go ahead, Andrea, if you have a question.
I was just, thank you. It's not urgent. As I was listening to Patrick, I was wondering, how the laws are different from state to state. And maybe this is not a question you can answer, but someone once told me, don't die in Pennsylvania because, the estate taxes and so on and so forth are so, heavy.
Sure.
Do you have
So
any advice about where to reside, set up so that we can provide for children in the best ways possible?
sure. So I often tell clients that, you know, taxes are one aspect of the plan, and the other aspect of the plan is where you're happy living, where your family is happy to be. And that's probably the bigger concern, especially these days when our estate tax exemptions have really gotten very high. So in Maryland, the estate tax exemption used to be $1 million per individual. Today, it's $5 million per individual, and a married couple has essentially $10 million of exemption from Maryland estate tax. The federal exemption is even higher. It is actually, around 13 million per individual. It may come down some in 2025 if certain tax laws sunset. So fewer and fewer people have an actual estate tax problem. There are other types of, for lack of a more gentle term, death taxes. One is inheritance tax. Maryland has an inheritance tax as well as an estate tax. The inheritance tax, though, only applies when you're leaving assets to a niece or nephew or further removed, someone related to you, or an unrelated individual. So if you're leaving assets to your children, they're exempt from estate tax, or excuse me, inheritance tax in Maryland. Every state is different, though, about how they treat their estate tax. For instance, Florida doesn't have an estate tax. Delaware, I believe, is pegged to the federal estate tax. South Carolina, I don't think has a state estate tax. Pennsylvania also has an inheritance tax. I don't have much experience with it though. So I would say that if you have a residence in another state, really it's even more important that you sit down with probably an attorney and accountant and go over, how to deal with those issues. But generally speaking, now Maryland with that higher exemption, we don't have as many concerns about the estate tax as we used to. When I started practicing, again, that exemption was $1 million per individual, and that affected a lot of people, and sometimes, unexpectedly. So it's certainly something that when you go to sit down with someone, they're going to go over. And it's certainly something to consider, but I think particularly when we have minor children involved, that there's a host of other things that we have to think about too, right? And then when we create these trusts for children, and let's say that they actually, when I write these documents, I hope that those trusts never have to be used, right? Because we hope that the parents live to an old age and there's no need for the trust. With that said, if the trust is created, that has its own income tax situation. It becomes its own taxable entity, okay? And then the trustee has to deal with basically filing a tax return each year for the trust and making sure that they're treating the income of the trust in the best way possible for tax reasons, while taking into account all the other reasons for the trust, right? But frequently we'll try to distribute income out to children because it's taxed at a lower rate than it would be within that trust. And that's getting a little bit into the weeds, but there are income tax consequences, not consequences, but things that you have to think about going forward if that trust is created. But again, it would only be created if everything held true. For instance, you passed away and your children were under a certain age, etc.
Thank you.
Any other questions, Katie?
I have a question, but I don't know if it now is the time to answer it, but I'm just wondering if you pass it, before you hope to, and you have young children and you're in debt, if you still have a mortgage, is that, I don't know if that's something you'll cover later, but I do wonder about that.
Yeah, that's something we can talk about now because it really kind of relates to the will. So to the extent that you own a home, you have other, debts that all of us have, maybe a car loan, maybe some credit card, debt, or just credit cards that you pay off every month, but have a balance on them every month. Your debts, generally speaking, do not become the debts of your family, meaning the only entity that's responsible for your debt at your death is your estate and the assets in your estate. Now, obviously, if you own a home and it has a mortgage, you signed a deed of trust or a mortgage that says, that they have a lien against that property. And that would hold true if it's joint with someone else, etc. And the remedy there would be that they may foreclose on the property if the payments can't be made or somebody can't assume the mortgage, right? Or if the property can't be sold to pay off the mortgage. Other debts, such as credit card debt or something that's kind of unsecured, right, would be they would file a claim in your estate, and to the extent there's assets to pay off that debt, it would have to be paid off before the assets pass out to the trust for your children or out to your beneficiaries, okay? I think the thing to remember, people think about, well, if I die, I'd like my children to be able to stay in the home, and whoever I've named as guardian, I want them to like move in with the children and take care of them there so that their life is disturbed as little as possible. I think in reality, there's a lot of decisions that have to be made when an event like this occurs. And it may be best that most all assets be liquidated and put in that trust, and that the child, go live with the person that you've named as guardian, just because it becomes difficult for them to try to maybe assume the mortgage or get approval to kind of keep the mortgage going. Particularly now, if I have clients who pass away who have a mortgage that had a very low interest rate, and now interest rates are much higher, it becomes even more difficult because the bank might not be willing to sort of let that mortgage continue without sort of creating a new mortgage for the new owner, whoever you've left the property to. But generally speaking, I think the thing to remember is that your debt is debt of your estate, but it's not incumbent upon your beneficiaries or your parents or brothers and sisters or anyone else to pay off that debt outside of what's in your estate. Any others that you see out there, Katie?
I don't see any others right now. I think we're good to go.
So let's talk a little bit about the other two documents that I spoke about, the financial power of attorney and the advanced medical directive or healthcare power of attorney. And we're going to talk about these in two respects. One for, you, and one for possibly for your children, okay? So why is it important for everyone to have a financial power of attorney? So financial power of attorney is a document that names an agent. We sometimes call them an attorney in fact. And it allows them to make decisions and to take action with respect to your property. That could be bank accounts, it could be retirement accounts, it could be your home, it could be vehicles, any asset that you have. It allows this person to step into your shoes and deal with those assets during your lifetime. Typically, this document is used if you're not able to make decisions anymore about those types of matters. So you may have seen this in the scenario of, an elderly parent and somebody is stepping in, a child to help take care of their bills, take care of their finances, and so forth. This document allows someone to do that without going through a sort of court-governed process for a guardianship. So it is important because that guardianship process can be time consuming and expensive. And the financial power of attorney really allows someone to step in immediately and take care of matters. It can also be used, for instance, you may have come across this in maybe a real estate settlement or something like that, where someone couldn't attend the settlement. So they name someone as their attorney in fact to sign the documents for them. What I see most in my practice is that we're putting these documents in place to plan for, the potential for not being able to make decisions at some point down the road in the future, and having the ability of someone to step in and help take care of matters for you if you can't. There are a couple types of powers of attorney that you might come across, either if you sort of search online or have a meeting with an attorney and talk about it. Maryland does have its own statutory power of attorney. It's a form that can be found in the Maryland statutes. I think you can even find it maybe on the Attorney General's website. And essentially, you fill it out and sign it, and it gives that person that you've named the ability to step in and deal with your assets. Powers of attorney can be effective immediately, meaning right after you sign it, or they can have an effectiveness when you become incompetent. So I will tell you that in my practice, most of the time, I make powers of attorney effective immediately. And that's usually because my client is naming someone they trust, so they have no problem or no worry that they're going to use the power of attorney in a nefarious way. And also because that power of attorney that becomes effective when you're incompetent really requires your agent to, take you to maybe one or two doctors to have them say that you can no longer make decisions, and can then lead to issues at financial institutions or other places you're trying to use the document of, well, how do we know if they're still, unable to make decisions? It brings a lot more steps into the equation than just having it be effective immediately. So typically what clients will do, will put this in place, and then what I tell clients is, let your family know that you've done your estate planning, and that if there comes a time when they believe that you need some help managing your affairs, have them be back in touch with me, and then I can step in and sort of help make that determination, and then help them move forward to take care of matters for you. I think the take home on the financial power of attorney with respect to your personal matters is that it's really important for the long term, meaning it's helping us plan for hopefully a situation that never comes to pass, but it does make sure that you have someone in place to take care of matters for you if for some reason you can't. And then let's talk a little bit about the healthcare power of attorney. So you may have seen this as a document called an advance directive. That's typically the Maryland form is called an advance directive. You may also see it called a healthcare power of attorney, or along with a living will. And these are documents, the healthcare power of attorney specifically, where you name an individual to make medical decisions for you if you're not able to. So this could be a situation where you're having a procedure done and you're under anesthesia and you can't make decisions, and somebody needs to be available to make a decision if necessary. Typically, if you go in for a procedure even sometimes outpatient procedures, they will ask for your your advanced medical directive or your healthcare power of attorney. The other scenario is more like the financial power of attorney we discussed, where you've permanently lost the ability to make informed decisions about your healthcare. And in this document, you've named someone to step in and make those decisions for you. Oftentimes, this might be somebody different than you choose for your financial power of attorney. They're different jobs, right? One is managing your finances, and one is sort of managing your healthcare and making decisions with respect to that care, taking into consideration what the agent thinks is best, but also what they know you would have wanted.
We have a question, Patrick, if it's okay to ask now.
Sure.
Jenny has her hand up and then Andrea had her hand up just a little while ago. So Jenny, why don't you go first and then we'll go back to Andrea. Are you there, Jenny? Okay, maybe she'll come back. Andrea, would you like to ask your question?
I think you answered it, but just for clarity's sake, you were talking about the financial power of attorney. And the first thought that came to my mind is, how is that different from the executor of the will? But then as you spoke, I understood it more as the financial power of attorney steps in while you're still alive. Isn't that right?
Right. So the
Okay.
financial power of attorney, they're very similar jobs.
Thought
The
so.
financial power of attorney is acting during your lifetime. As soon as you pass away, the power of attorney goes away. It's no longer effective. And then your executor steps in and begins to manage your estate. So oftentimes people will choose the same individual for those two jobs just to have things sort of streamlined.
Mhm.
But that's correct. It's just effective during your lifetime.
Thank you.
Well, I'll move on just a little bit more about the healthcare power of attorney. Um, although I think I covered that pretty well, that essentially you're naming someone to make medical decisions for you. And those could be decisions ranging from what type of treatment you should receive to, um, you know, if you can't live at home anymore in your old age, where you should live, how you should receive care, who your doctors should be, all those sorts of things. Um, in addition to a healthcare power of attorney in the Maryland Advance Directive, there's also a section that deals with sort of end of life care. And oftentimes you'll see this referred to as a living will. This document, you really don't appoint an agent at all in it. It's a decision that you are making about the type of care that you would want at the end of your life. And you put it in place so that your loved ones don't have to make those decisions. So the living will would say, for instance, if I'm at the end of my life and there's no expectation that I'll have recovery to a meaningful life, and that the doctor who's providing my care has said death is imminent, that I want to be kept comfortable and given medicine for pain, but otherwise I want to, pass away naturally without um, artificial nutrition or hydration, etc. So essentially, I think the key points around the living will are it takes that decision out of anybody else's hands. You've made the decision yourself. And second, for this document to come into play, again, death has to be imminent. So for instance, if you are in a car accident and there's a reasonable expectation that they can take action to save your life and bring you back to a meaningful life, they're going to take that action. A lot of times, medical procedures, for instance, during COVID, I had questions of what would this mean if I had to go on a ventilator or something like that? Well, I think in that case, if there was a reasonable expectation that that action could help you to recover, then they would go ahead and take that action. The living will is really going to kick in if we're at the end of life. Okay. And again, I think it's important to have because It allows you to express your wishes. The alternative is that your healthcare power of attorney would make that end of life decision, okay? And if you don't have any healthcare power of attorney or living will at all, then we get into a situation where maybe, again, we have a hierarchy of people who can make the decision, or maybe we have to have a family meeting with siblings or you know, brothers and sisters and other individuals who may have to help make that decision, for instance, a social worker at a healthcare facility, et cetera. So I think the healthcare power of attorney is an important document to have to, again, make sure that to the extent possible, we've put the individuals in place that we want to make decisions for us if we can't make them ourselves any longer. Okay? Are there any questions about that before I go?
Yeah, we have
Okay.
two in the chat. The first
Yeah, I
one,
see that.
yep. Is healthcare power attorney the same as a health proxy?
Yes, generally, so your healthcare power of attorney and health proxy would be the individual to make decisions for you if you're not able to. If I do not want an immediate power of attorney, would a springing power of attorney be an option? Yes, so the springing power of attorney is what I explained as becoming effective when you're deemed to be incompetent. You no longer can make decisions, and that's been sort of typically the power of attorney itself will state the process for making that determination, whether it's your your primary care physician or two doctors. There's all sorts of ways that it could be determined. But that springing power of attorney is an option. Again, as I stated, it does involve a few more steps before someone can really step in and take care of things for you. But I do understand why people like the springing power, just because of the amount of power that a power of attorney gives to someone with respect to your property. Kirsten, did you have a question?
Yeah, I did. I was wondering about with the healthcare power of attorney, I always thought of that as being something, now that I'm getting older that I need to have. But we were talking to some people and they were talking about it's a good thing for young adults, 18 to 25, who aren't married, single. Is it advisable for them to also have a healthcare power of attorney? I mean, does it make, if there was to be an accident or something, would it be harder for the family to get input or communicate with doctors?
Sure.
If
Yeah, that's the next thing on my agenda.
Okay, thanks.
And also that living room looks very familiar.
Oh, it's been painted since then.
Yeah. So the next thing that I was going to talk about was why these documents could be important for your children. Okay, particularly minor children, obviously not as much of a concern, because as parents you have the right to make decisions for them if decisions need to be made. But as children turn 18 and go off to on their own, or even if they're still at home, they're at college, whatever it might be, once they're 18, to the extent that there's not some other circumstance where you're their guardian after age 18 for maybe a medical reason or something like that. If they're over 18, it's not necessarily assumed that their parents are the ones that can now make the decisions. And I think that might go state by state. I think, but in order to avoid any question, and I've started doing this, with some of my clients now that have children who are going off to college, why not put these documents in place for that child who's turned 18, so that, again, if there is an accident or something happens and someone needs to make a medical decision, you have that document. You can email it to the hospital and say, okay, I have the ability to make these decisions. Also a financial power of attorney. For instance, what if you need to handle some financial matters for a child who isn't living at home anymore, is in college, or whatever the case may be? That would allow you to take care of those matters for them. So I would say that they may not need a will, because they probably don't have any real property for a will to control just yet. But definitely, I think when a child turns 18, looking into having a financial power of attorney and a healthcare power of attorney for them is important. The living will aspect of the healthcare power of attorney is a little difficult to discuss, like with an 18-year-old, though, I've found, because they're like, usually that's something we think about at the end of life, right? I mean, somebody that's older and has lived a long life, and they want to just pass away peacefully. When you're 18, I don't know that you really grasp the whole concept of that end of life, that potential end of life decision. So sometimes it might just be that having the healthcare power of attorney in place is best, and then that person can make any decision that needs to be made. But I do think that it's becoming more and more important, because I just don't think in today's world that you can rely on, well, I'm their mom and dad, of course I can make this decision for them. You might run across a situation where someone says, well, I don't know who should make the decision. Or what about the case where maybe two parents are divorced, and then who makes the decision, right? If everybody's not unified. So it really becomes, incumbent upon, and I think at 18, a child is old enough to be able to decide who they'd want to make that decision if they can't. That's essentially what I wanted to cover. So I'm happy to answer any and all questions that anyone has. Again, just as a summary, we talked about the three documents: will, financial power of attorney, and healthcare power of attorney or advance directive, and really sitting down with an attorney to talk about the various issues, because everybody's going to have different issues with their own family and their own situation, and really help guide you through those decisions of sort of what we talked about with protecting the assets for your children. If you pass away, sort of unexpectedly.
Patrick, could you talk to us about the process of creating these documents with an attorney and a state attorney like yourself?
Sure. I'll answer this one. I'll do that. First, I'll answer this question here in the chat. Are you able to avoid probate if you have a will? A will essentially requires probate in order for it to dispose of your assets. There are other ways to avoid probate, and you've probably heard of some of these. Obviously, that joint ownership of property that I spoke about earlier, to the extent property is owned jointly, those assets pass to the joint owner without going through probate. To the extent you have a retirement account with beneficiary designations, those assets go to the beneficiary outside of probate. To the extent you have a bank account or an investment account that has a transfer on death or payable on death beneficiary, TOD or POD, those assets go to the beneficiary outside of probate. I think what you have to be cognizant of if you're avoiding probate is that those designations mean that those assets immediately belong to that individual upon your passing. They have to go and take a death certificate and talk to the bank and so forth, but it's their asset. So, for instance, if a family has multiple children and they put one child as the joint owner on an account, or one child as a beneficiary of an account, I'm talking about adult children now, that child has no obligation to share the assets with his or her brothers and sisters. Okay. So if you're putting beneficiaries on assets, you want to make sure that they match what your intent is. And even though you may feel that you can totally rely on someone to make the best decision, I will tell you that when someone passes away, it has an effect on people that's sometimes unpredictable. And it can have effects on families that is sometimes unpredictable. So really what I try to do is make sure that we have everything set up so it matches exactly what you want done, to the greatest extent possible. The other way to avoid probate is the use of a document you may have heard of called a revocable trust or a living trust. And this is a different type of estate planning where you take your assets and you retitle them into this trust document, okay? So that they're no longer owned in your individual name, so that we no longer have to go through the probate process. Those assets are then governed by that revocable trust document. And if you go, online and Google about revocable trust, you'll find a ton of information about them and why they may be useful. Okay. So the process, Katie, that you asked about, I'll tell you how my process works. Everybody's going to have their own process. Typically, when I meet with a client, I may send them an email initially saying, here are some things to think about before we meet. For instance, who are you thinking about to be your personal representative or a trustee for your children or a guardian of your children? And I usually ask clients to bring sort of a summary of their assets and how they're titled, so that I can have a clear picture of whether we need to talk about estate tax planning, whether we need to talk about asset protection, whether we need to talk about special needs trusts, and so forth. So I can have a little bit of advanced knowledge about the situation. And then typically we'll sit down for maybe a half an hour to an hour and go over, just like I did tonight, go over the 3 documents and all the various decisions that need to be made about those documents. And then in my practice, I do my planning based on a flat fee. And so we would have a conversation, and then I let you know what the cost would be for me to prepare the documents. And if you wish to move forward, we move forward. And if not, there's no charge for the consultation. It's just you've decided not to move forward, and that's okay. I'll tell you that doesn't happen very often. And then I would draft documents, send documents out to the client for them to review. I would answer any questions, with a follow-up telephone call or Zoom. And then we would finalize the documents and get together and meet and sign them. In Maryland, wills have to be witnessed by 2 disinterested individuals. They don't need a notary. Power of attorney, you have to have 2 witnesses and a notary. The notary can serve as a witness, so you need 2 people, one of which is a notary. And the healthcare power of attorney, you need 2 witnesses. So to that extent, we provide that service as well, making sure that we have, the proper witnesses, that everything's signed appropriately. And then typically you would get copies of the documents. The original will might be filed with the Register of Wills office in the county where you live. And now I keep also electronic copies of all the documents. I scan everything in so that, if it's the summer and I'm at the beach and someone needs their healthcare power of attorney, I can, send it off to them immediately. So that's all kept in a secure, cloud and so forth. So that's the general process for me. And generally, if the client is clear on what their wishes are, and we kind of go straight through the process, I would say, in a month from when we meet, we've signed the documents and everything is in place. Some attorneys may ask for, if you go to see an attorney about estate planning, they may ask for a retainer. They may ask for, half of the total fee or a certain amount up front. I don't do that, but some attorneys certainly do. Some attorneys might say that they bill hourly and tell you what their hourly rate is. And that's fine too. I've found that everybody's more comfortable if we know up front exactly what to expect. So that's how I sort of handle things. And we try to keep it as, I don't want to say informal, but it's a difficult topic to talk about. So really I try to make it as much of a discussion as possible and not sort of a cookie cutter approach. I'm really looking at each person and trying to have, as I think most attorneys do, try to have a conversation about really what their wishes are and how we can best effectuate those wishes through these documents. What other questions are out there? We got a few minutes left.
I'm not sure if you can hear me now.
I can hear you. Yeah.
Oh, good. Okay, so this is Jenny. My question from before kind of, I guess, ties into everything that we've talked about. Is there a way to protect your assets in the event of, say, my husband and myself were in a car accident? One of us passed away, but the other who survived now needs long-term care for the rest of their life. Is there a way to protect your assets for your dependents from, like, a nursing home or a medical facility coming after?
Sure. So that is sort of a whole other universe of estate planning. There's two ways that it comes up. Oftentimes, older individuals are saying, how can I protect my assets for my adult children so that they receive an inheritance? And it might be called elder law or Medicaid planning, which essentially you're trying to shelter assets so that you could qualify for Medicaid or state assistance for long-term care. There are all sorts of things that you have to think about with that, particularly the fact that, long-term care costs, Medicaid only pays for long-term care costs. So what if all you need is assisted living or maybe in-home care? The idea of gifting assets to children and whether they, will be able to manage those assets, or whether they're willing to kind of help with your care using those assets if necessary. And then there's a lot of rules, federal and state rules around it.
Mhm.
The situation that you're speaking of, again, protecting assets from long-term care really is going to involve giving up some level of control, because as long as you have control of the assets, they're going to be deemed available for your care, right?
Right.
So probably the best protection that you could have, depending on your age and health, is probably looking into like some sort of like long-term care insurance or disability insurance or something like that. Because then that, helps pay for that long-term care while preserving the other assets, right? Otherwise, you're really looking at taking assets out of your control and putting them in maybe an irrevocable trust or gifting them to children, which you can't really do with minor children, right?
Right.
And really sort of tying your hands for a situation that really, depending on maybe what your profession is or what your hobbies are, might be pretty remote.
Unlikely. Mm-hmm.
Yeah. So, but I do think that, talking to a financial advisor or an insurance agent about, the types of insurance that would protect your family if, again, maybe it wasn't some sort of catastrophic event, but there's an injury that prevents you from working or whatever it may be.
Mm-hmm.
That's all sort of part of this. And I think one thing maybe I didn't mention is that part of my job as an attorney in advising clients is to work with their accountant and their insurance advisor and their other professionals, financial advisor, to make sure that what we're planning all works together.
Mm-hmm. Okay. Thank you.
Mm-hmm. Any other questions? I don't think I see any more in the chat, Katie. Did you see any more, or anybody send any directly to you?
I don't see any in the chat, and there are no longer any hands up.
Well, let me see if I can put my email here in the chat, and then everybody can see that if they need to.
And I can also send your email out with the follow-up
Sure. And please, like, if anybody has questions, do not hesitate to email me. And I'm happy to answer those questions. I promise I will not send you a bill. So just email me and I'm happy to give you some guidance to the extent I can on a particular situation or question that, and I realize that there might be questions that some people are, you know, uncomfortable asking in a group. So I'm certainly happy to have a short phone call or email conversation about those questions.
Okay, great. Well, thank you so much, Patrick.
Okay,
Been a very, very helpful conversation. I think we've all taken a lot from this, and yeah, we're grateful for your time.
okay.
Thank you, Patrick.
You're welcome. Bye now.
Bye-bye.
Good night, everyone.
Good night, Katie.